A very good afternoon to all of you. My name is Arfeen Usmani, and I'm going to be your tutor for this subject, Corporate and Business Law. So I would initially like to give a brief introduction about myself. So I'm a member of ACCA, currently working in an MSc, and I have been tutoring the subject of APM and Corporate and Business Law in VGLD. So I'm just looking forward to make this class a room for growth, a space for learning, and a bit of fun along the way. So this was a brief intro about myself. So yeah, anyone wants to give introduction about themselves? Yeah. Yes, Ritika, would you
Hi,
like to?
ma'am. My name is Ritika.
Yeah.
I am from Patna, Bihar,
Okay.
and I have given two papers, FA and BT. Recently, I have
Okay.
given FA.
Can you speak a little louder? You're not audible.
Now it's okay.
Still, yeah.
Now?
Okay. So you have attempted two subjects till now.
Yes, ma'am. I recently given FA,
Okay,
which I secured 80%.
fine. So,
And I am pursuing economics honors as well as in my bachelor's. That's
okay.
it about me.
So, is this subject law, have you done earlier any other curriculum, or is it going to be your first time you're doing the subject law?
The subject law
Yeah.
specifically, I'm doing it first time.
First time. You're not aware about it, like how it is all about?
I know about the pattern,
Oh,
like how exam goes, and MCQ patterns, MTQs, 10 marks, 15 marks questions, and this is on demand. Study Hub, I am also aware about it.
okay.
This
So,
is like a knowledgeable papers now.
okay. So now it will be a very interesting subject for you because since it's my favorite subject is law. So I'm going to,
Since I am not very good in theory, I am good more in practical, so I am hoping
okay.
for that good marks.
No, no, you're going to score really well.
In BT
It's a very
also,
interesting
I
subject.
didn't
It's not
score very
very,
well.
no, it's very, you can say it's not very theoretical or you'll feel monotonous. It's not like that. It's a very interesting subject.
But when you says that law is very technical, the term is technical, so differentiation is also a technical.
Okay. So I'm sure you're going to like this subject.
Maybe let's see.
Yeah.
There is only me in this class. It is very interesting. Like
Your,
only
sorry, your voice is not audible. In between, it is disrupting.
I am saying that only me in the class. Like it is very interesting. I haven't seen
No,
that only me in the
students,
class.
students join in between. And since it's in the afternoon, so yeah, so depends.
People are sleeping.
Yeah.
No, no. Like,
Yeah. Okay. So this is the introduction. I'm sharing the video. Please watch. Okay.
This exam develops your knowledge and skills in understanding of the general legal framework of specific legal areas relating to business, and your ability to recognise scenarios where it is necessary to seek further specialist legal advice. ACCA recommends studying with an approved learning partner and using study materials from our approved content providers. However you study, ACCA will support your learning journey with a range of free resources. There's study guidance to help you get started, and support throughout your learning journey to get you exam ready. There is guidance from the examining team, including examiners' reports, which provide constructive and detailed feedback, and there are technical articles, exam technique guidance, as well as videos and webinars to support your studies. This is a 2-hour exam and is divided into two sections. Section A is worth 70 marks. It contains 21 mark questions and 25 2-mark questions. The whole syllabus is open to be examined, so it's important to prepare thoroughly. Section B contains 5 6-mark multitask questions. They concentrate on analysis and application of learning. The questions are presented as problem scenarios and contain a series of tasks. Using the resources available from ACCA and your approved learning partner is the proven route to exam success. So good luck with your corporate and business law exam from everyone at ACCA.
So fine, this was the introductory video which is being specified by the ACCA itself. So
Ma'am, we are going to study global variant now.
yes, you're going to study the global one. Fine.
Okay, okay.
So here comes the syllabus. So I'll guide you through the syllabus once. So corporate and business law is basically divided into 8 areas, and it basically starts with the introduction of the legal systems, the different types of laws, and those organizations which endeavor to promote internationally applicable law. So which kind of law it is there? It is basically the international law, that is the global law. It also introduces the arbitration as an alternative to court adjudication. This all terms you're going to understand later on, which when I'm completing the chapter. So the syllabus basically covers a range of specific legal areas relating to various aspects of the international business of most concerns to the finance professionals. So yeah, on successful completion of this exams, then you will be able to identify the essential elements of different legal systems, including the main sources of the law, the relationship between the different branches of the state constitution, and the need for international regulation, and explain the role of international organizations in the promotion and regulation of the international trade. Then you will be able to recognize and apply the appropriate legal rules applicable under the UN Convention on contracts for the international sale of goods, and explain the various ways in which the international business transactions can be funded. Then you will be able to recognize different types of international business forms, distinguish between alternative forms and constitution of business organizations, recognize and compare the types of capital and financing of companies, then recognize the legal implications that is relating to insolvency law, and demonstrate the understanding of corporate fraudulent and criminal behavior. So here comes the syllabus. So part A, you can see the different chapters are being provided. Then second part related to the international business transaction. Third is basically to the transportation and payment of the international business transaction, the formation and constitution of business organizations, capital and the financing of companies, the management, administration, and the regulation of companies, insolvency law, corporate fraudulent and criminal behavior. So these are the broad classification. Under this, the different chapters are there. So here the detailed guide is being given. This you will understand once you have completed the chapter. So here comes the approach to examination of the syllabus. Since you know this is an objective exam, right? You know, are you aware
Yes,
about it?
ma'am. Yes, ma'am.
It is an objective exam, and it is you can say whenever you demand, it is a demand-based exam. So there is no specific timeline that you have to attempt. You can, once you complete the syllabus, as soon as you can give your exam, right? So
Yes, ma'am.
section A, you will be getting 2 marks objective test question. That is 25 questions you will be getting. And in 20 marks, you can say 20 questions, 1 mark objective test questions, that is comprising your 70 marks. So depending upon the questions, 2 marks, 1 marks, there you will be getting total 70 marks. Then in section B, you will be getting more scenario-based question, where a little bit case study sort of will be given, which I will be doing in the class. There you will be getting how many questions? 5 questions, that will be comprising of 6 marks. Again, 2 to 1, 1, depending upon the question. So that will be comprising your total 30 marks. So here 100 marks total objective questions, and all of the questions are compulsory. Fine.
Yes, ma'am. And what is the standard of the exam? Like very high standard?
No, it's very normal. If you're thorough with
Mm.
this subject, like you can easily gain very good marks. Last batch which I have taken, students have really scored very well. So
Mm.
yeah, you can actually attain a good marks. You can easily get 80, 85 very easily. Once you are thoroughly prepared, you can easily score.
Like,
Right?
how many times we should revise this
How
subject?
many times now? It depends upon your capability.
Uh,
It depends
like
upon individual
first time
to
if
do
I
very
study,
well.
then
Yeah.
if I study first time, then the things
Okay.
will take time to retain.
See, once you are grabbing the subject, see, it depends upon you, right? How you are
Mm.
taking the subject, how much interest are you getting, and how much time you are devoting. So it totally depends on you. You can
Ideally,
easily catch it in the first instance, or you might take time. So that is subjective,
yes.
right?
But ideally, we should take how many times of revision?
See, what ideally, as many times you are revising, it is good for you.
Okay. Since you have a previous batch also, then how
Yes.
many times student revise?
So that, see, again, it is a subjective matter. Some catch very easily and very fast. They are very responsive in class, some students, and some may take time. So it totally depends. If you feel that you are confident, you can retain. So you don't have to revise several times. If you feel difficulty, then you have to do it, right?
Yes.
Yeah. So it depends upon your capacity. Here you can see the different chapters are there. Total 19 chapters are there. So now today I will be starting with this chapter, that is economic, political and legal system. So if I'm going to ask you law, so what do you understand by this term law?
Law is something which binds us to do. We
Yeah.
cannot. Law is something that which bind us. We cannot over boundary with this
Okay.
line.
Basically, you want to say that it is a set of rules, right?
Yes,
Rules and
ma'am.
regulations.
Which binds us.
And who establishes this rules and regulations?
Political system.
Political system. Okay. Are you sure?
Yeah, which kind of economy we have depends upon which kind of political we get.
Okay, very good. See, you're very smart.
Since if we have a socialist type of economy, then we get a like what the term is, I forgot.
Basically, if you want to
Uh,
explain it in simple terms, you're going to say any governing authority, right? Will establish the rules and
yeah,
regulations.
monarch system. If we
Any
are so
regulatory authority would be there, any form of, depending upon the country, right?
yes, ma'am.
And
Since India is a mixed
why,
economy and they have
yeah,
a
okay, yeah. So
and
again, my
they have a,
question is,
democratic political system.
very
So
good.
it
You
is
are aware of so many
interchangeably.
terms, and you are so afraid. Why? Very good.
Um,
Yeah, I'm impressed.
thank you, ma'am.
Yeah, really. So you tell me why this law is being established. What could be the reason behind it?
To run a country smooth. That's why.
Okay. Basically to regulate the individuals, right?
Yeah, in a smooth manner.
Yes. You are regulating the individuals, or you can say the authorities, the different authorities. So that is why law is required. Okay. So here, is my screen visible?
Yes, ma'am.
Okay. So law is a system of rules and principles that is being established and being enforced by a governing authority. Any of the governing authority? Designed, why it is being designed? in order to regulate the behavior of individuals and institutions within a society. So why it is being required? In order to maintain the order, to protect the individual rights, and to ensure the justice and provide the framework for the resolution of the disputes. So now comes the key functions of law. Why law is being required? First of all, in order to maintain the order, law and order within the country. That is, it provides a predictable and structured society by defining the acceptable standards of behavior, what kind of standard that is being required. So you need to abide by that. Then protecting rights and liberties. It safeguards the fundamental rights and freedoms of individuals, such as the right to life, property, and equality. Then comes the resolving of the disputes, like through court and legal processes. The law provides mechanism in order to settle the conflicts fairly and peacefully. Then establishing standards, like it sets the rule and expectation for the social, commercial, and professional conduct. And then comes the final part, that is the promotion of the justice. If there is no law and order within the country, then what could be the repercussions of it? Tell me.
Repercussions.
Yeah.
Ma'am, repercussions.
Like if there is no law and order, so what could be the problem that could arise?
Like anyone overruled to anyone. So if someone is rich, they can dominate the poor one. If someone is strong by physically, they can dominate the unhealthiest person.
Okay.
So it
The
goes,
advantage could be taken of their power, right? Of their money,
yes,
their power, their status.
yeah, this is the
Oh,
one aspect, and there are many we cannot even imagine like what's going without law. Even though past history we have a monarch system.
oh, yeah. So basic purposes in order to promote the justice. There is more of justice within the society. No one feels that they're not getting justice, right? No one will feel that they're being left out or they're being segregated, they're not being heard. So feeling of belongingness should be there within a society. So law aims to deliver justice by holding individual accountable for their actions and promote more of fairness. There is more of equity, right? One should be more morally acceptable, right? So this is all about law. So what is law actually? Okay, now I'm coming to the chapter. Here comes the economic, political, and legal system. This is your first chapter. So here's the chapter overview that is being provided. That is types of economic, political, and legal systems. So there will be the types of legal systems that will be provided, types of economic systems, political system, under legal system, law and legal system, types of law. Then again comes here the common law system, that is the common law and the role of judges, civil law, Sharia law. So all these you're going to learn about in this chapter. So under the exam focus point, exam questions on the topic in this chapter are most likely to be looking to test your knowledge and understanding of distinctions between the different kind of laws, and so are unlikely to be scenario based. What they're trying to say is that under this, like the section B question, there will be more scenario based question. So you will expect less from this chapter under section B. You should not rule out the possibility of scenario questions being said, though what they're saying is that you just can't ignore it. This chapter that, okay, it will not come. See, you have to complete all. You can't just leave any chapter. Under objective questions, any question could come. And the ACC will try covering each chapter. So whether it is scenario based or whether it is the section A, everywhere you are getting the objective question only, right? So you have to be thorough with all the chapters.
Yes, ma'am. Ma'am, one question is that
Yeah.
since our subject name is corporate and business law, what is the difference between corporate law and business law?
Corporate and business law.
Yeah, what is the difference between these two?
So if I'm going to ask you, what is corporate?
Corporate is multinational MNCs.
Companies, corporate
Yes,
means
ma'am.
companies, and business.
Business is also a
Is
multinational
it a
MNC,
company?
small.
No. Okay.
It can be small, it can be big.
Again, you're conflicting it. What is business?
I don't. Ma'am, I am not recall it.
In very easy terms, what will be the business? That is the trading of goods, or you're providing service, any kind of business a person could be.
Yes, ma'am.
A company, a corporate is being established. What does they do? They do business, right?
Yes, ma'am.
So the laws will be different.
No,
Why?
because a corporate is extension of business.
Corporate is extension of business.
And business can be small or big, but corporates are usually
companies-
big companies.
Once a company gets established, a company is formed, okay, that you know,
Yes, ma'am.
a company gets registered itself. Companies is a separate legal entity
Yes,
that
ma'am.
you know. See,
Yes,
I
ma'am.
will explain you in detail everything, okay, in the
Okay.
later part of the chapters. That is how the company is being established, how like the business is being started. Everything will be explained, okay. But initially, you have to understand this corporate is relating to the uh, companies, the corporations, and how the business is being governed, the international business, the different laws that are being applicable, the international laws. So it relates to that. Fine. So
I'm still not getting what is the difference between these.
you will get, once you will be doing the subject, you will get, okay?
Okay.
Fine. So first comes the economic, political, and legal system. So here comes the types of legal system. Although law is a global concept, but it is usually organized on national lines, depending upon the countries. And there is only limited amount of truly international law. If any international law is there, so it will be applicable to most of the countries. So in this course book, we shall consider some national laws that have been examples for other countries developing their legal systems. So there are three types of legal system that is operating in the world that have been adopted by different countries for different reasons. That is common law, civil law, and Sharia law. So we are going to do this in detail. First come the economic systems. So economics, you know what is economics?
Yes, ma'am.
What is it?
Ma'am, economy system is how to produce, to whom to produce, and why to produce.
Why to produce? It is related to the economy, right?
Yes, ma'am.
So here economics can be described as the ways in which society decides what to produce, how to produce, and who to produce it for. And decisions need to be made regarding what resources should be used, how much should be paid for them, what goods should be made, and what the price of the goods should be. So this all part relates to the economy. So there are basically three kinds of economic system, that is planned, market, and mixed economies. Under planned economy exist where the decisions and choices about resource allocations are being made by the government. And all the decisions related to the resources and all the decisions related to the economy are being decided by the government. Although the individual might be allowed to own some personal possessions, most kind of wealth would not be available for ownership by individuals. Then comes the market economy. It exists where decisions and choices about the resource allocation are left to market forces of supply and demand and the workings of the price mechanism. In the market economy, most wealth is being owned by the individuals, with a minimum being collectively owned. There is a sort of, you can say, it is being depending upon the market forces, how the price and supply, how is price affecting the supply and demand of goods within the economy. Then comes the mixed economy. Under this, decisions and choices are partly being governed by the free market forces of supply and demand and partly by the government decisions. So what is it? Is a mixed economy. Now, how are you going to get the questions? You will be getting the definition, right? And then you will be asked whether it is a planned economy, market economy, and mixed economy. Okay? It will be as simple as that. Any question?
Ma'am, in plan economy,
Mm-hmm.
individual cannot there take a decision of
No, here
personal
all the decisions are being taken by the government.
personal decisions also.
See, here you have to see from a broader picture, from the economic point of view, right? So even if an individual is there, for example, in dictatorial system, as is being specified, in countries where the individuals have to be abiding by the rules that is being set by the government. So you know any country where dictatorial system is being followed?
Yes, ma'am, that North Korea.
North Korea is the very good example. So their citizens have to follow. Okay?
Yes,
And democratic system example?
like India,
Very good.
England, America.
America, right? So here it depends upon the where the dictatorial system is being applied or where the democratic system is being applied. Okay. So the types of political system, lawmaking can be a democratic process where law is developed by citizens, or more a dictatorial process where law is developed by a government put in place by another method, for example, a military coup. So what process is in force in a nation also affect two very important factors, that is the rule of law, what is the law that is being established, and the separation of powers. So the rule of law says that how and what laws are being made and enforced in a country depends to a large extent on the emphasis that country's political system places on the nature of the rule of law. This is the degree to which individual behavior is being regulated by the law. Then dictatorial system, here it tends to have more emphasis on the state or government regulation and the control of resources, as we've discussed. More of government intervention is there. This means individual freedom is heavily subject to the rule of state-made law, and the behavior of individual is to a large extent being dictated by the state by means of law. Now comes the democratic system, that is also known as laissez-faire political system, which means having the minimum intervention by the government. So the emphasis on the law being a means of sorting problems out where they are being arisen, provided individual act within the letter and the spirit of the law, and they are free to choose for themselves and how they regulate their lives and how they relate to the people and the groups. It all depends upon the individual decisions. Now comes the bodies that are being involved in law. Most democratic nations in the world have held in different places, so that more part of the political process has too much of influence. So these have basically three elements. First is the elected legislature, which says that just give me a minute. So it is a body which enacts, amends, and repeal law, cancel law so that people's wishes for freedom, wealth, etc. are being met. Members of the legislature are elected by the people and represents the area of the country in which they are residing in. So in the UK, Parliament is the legislature, which is consisting of the House of Lords and House of Commons. Then comes the elected executive, that is the government body. It is a body that decides which law should be putting in action. A nation's head of state and head of government are the main two roles in the executive. So now see, this is important. How? Because since you're getting objective questions, so you will be getting this kind only. Like what is the, you can say, it could be asked, what are the two main roles in the executive? So you should be knowing that is the nation's head of state and head of government. So this is all learning part you have to do. So the executive does not make the law. Instead, it instructs the legislature as to what law should be made. So they're not sort of making the law, but they are instructing who is making the law. Legislature is making the law, but the guidance part who is doing? The executive, the elected executive. In the UK, the executive is the political party that can command a majority of the House of Commons, that is a House of Publics. So in practice, the decision of executive are being taken by the Prime Minister and the Minister of State. Then comes the judiciary. So a body that rules on any dispute about laws and whether between the government and the people or between individuals. So the role of the judiciary is to interpret and apply the laws that is being created by the legislature. So what is judiciary doing? What is the role of it?
To interpret the law.
To interpret whatever law is being formed by the legislature,
Yes, ma'am.
to interpret it, to provide the guidelines, or to apply the law that is being created. So this function is being done by the judiciary. And who is forming the law, creating the law?
Apply the law. You mean to say they approve the law, what the legislature makes?
What law shall be applied? See, if a government, for suppose, or authority comes up with the law, so there are several processes in order to apply that law within the country. So that part is being done by the judiciary. Okay. And if certain clarification is being needed, see, certain times what happens, like budget comes. So certain points or income tax, any amendment comes. So certain points are there which are not being easily understood. So then again, a clarification is being issued by the CBDT. Okay. So that is the clarification that is being provided, or like interpretation, if one is not being able to interpret it correctly. So that is being done by the judiciary. Fine?
Yes, ma'am.
Okay. So now comes the example that is being given. So you don't have to learn all this. It's just for your understanding purpose. In the UK, the head of state is the monarch, while the head of the executive is the prime minister. In France, there is president and prime minister. However, in the US, the president is both the head of state and the head of executive. It's just for your knowledge purpose. Now comes
Ma'am,
the
in US, president is both the head of state and head of
head of
executive, but
executive. Yeah.
we have a segregation of duty. Is it a breach of segregation of duty?
See, it depends upon their law, what they have said, right? We are, yeah, yes, there is a
Yes, ma'am,
distortion.
now fine.
Yeah, sound is there.
Yes, ma'am, the table is going there.
Okay, fine. So now comes the legal systems. So it can be used in two senses, that is to describe the body of laws and mechanism for their enforcement in the countries, and to describe the underlying nature of the country's law. So here it is all about the legal system. So law and legal system is, It is, as I have explained you, it is the body of rules that which is enabling the society like how to operate. It is guiding, it is a sort of a guiding mechanism. As such, it does not have to be written down, but can simply be rules that everyone in the society knows. Many states have written constitutions outlining citizens' basic legal rights and body of national law or rules which govern how the state is going to be operating. This is known as the positive law, where there is a proper written constitution which is actually acting as a guiding light, like how the citizens have to operate. So what it is known as positive law. A legal system in a country embodies both the law of that country and mechanism the country has in place for regulating and enforcing those laws. Now comes the elements of a legal system. A legal system incorporates the country laws, the legislature. Who is the legislature?
Parliament is the legislature.
No, you don't have to refer to your country right now. I'm just asking what will be the legislature.
Those who makes the law.
Lawmaking body, right?
Yes, ma'am.
Judiciary is the body that sits in judgment on disputes about the law, that is interpreting and applying the law, right?
Yes, ma'am.
Prosecution system, the system that seeks to ensure the criminal law is being enforced and people who break the law are getting the due punishment. That is the prosecution system. The police, the body which seeks to enforce the law and protect the public. We know, you know about who are the police system. The prison system, that is the system that ensures people who have broken the criminal law are being detained according with their sentence, like depending upon the level of crime, they are getting the punishment. So the prison system, are you aware of about it? The prison system?
Yes, ma'am.
Getting the term of imprisonment depending upon the nature of the crime that the individual has committed.
Yes, ma'am.
So the legal system is also used to describe the underlying nature of the country's law. If somewhere the legal system is too strict and somewhere it is not very strict. So it depends upon the country's law. Now comes the
Can you please repeat the prosecution system again?
prosecution system.
Yes,
So
ma'am.
here, if you know what is the term prosecution means.
Prosecution is the like opponent side of the court judgment when the court is going on.
Opponent part. Have you heard about this term prosecutors or prosecutions?
Yes, ma'am. In law, like in courts.
So what if, okay, I'll ask you, the system that seeks to ensure, that is making sure that the criminal law is being enforced, that is being properly applied, and people who are breaking the law, who are going against the law, are being prosecuted. What do you understand by this line? Just see, what I am trying to do is, I'm making you understand the law terms, like how you have to comprehend the sentence. It's a very easy one. But you should be knowing how to analyze it. That is why I'm making you do the exercise.
Like
I'm giving you a minute, just think, and then tell me. Then the chapters will become very easy for you. Once you start understanding the language of the law, it will become a very easy task for you. See, a person, for example, if you have some sort of done any sort of act which is against the law, right? You are committing crime, for example.
yes, ma'am.
Then what? You will be getting punishment,
Yes, ma'am.
either in terms of fines or either in terms of imprisonment, which means you are being prosecuted. Okay?
And this is going under a prosecution system.
Prosecution system. Clear now?
Yes, ma'am.
Okay. So what you have to do somewhere while revising yourself also, if you get stuck anywhere, you're not understanding what this could mean. See, since this is your first class, right? You might feel somewhere that, okay, I'm not being able to understand, or I might be feeling some sort of difficulty in getting the terms and line. Don't get worried at all. Once you will be completing the second and third chapter, you will become a pro. Fine? Don't
Okay,
get
ma'am.
worried for anything. Now comes the types of law. That is the main distinctions to be made between the types of law are between national and international law. National law means which is within the country, domestic
Yes,
country. And international means that is being applied to several places depending upon the law. And then comes the criminal and civil law that will also I'll be explaining. So conflict of law occurs when people from different legal jurisdictions trade with each other and their respective legal rules are getting in conflict. So national law, each nation has their own set of laws which regulate how entities within it and with each other or within the states are being related to each other or being governed. That is the national law. International law is the system of law regulating the relation between the different sovereign states and the rights and duty they have with regard to each other. It attempts to resolve the problem of conflict of national laws. So why this international law system would have been introduced? What could be the reason behind it? If I ask you to please think over it.
Ma'am, can you please repeat what you have asked?
See, this international law system, why it has been introduced? What could you think could be the reason?
To make a global relation better, like
There
a
is
G20
proper law and
summit.
order, right? No,
Yeah,
no
United
countries at
Nations.
no countries at disadvantage. There should be
Recently, we have a war with Pakistan, and United
yeah,
Nations doesn't interfere, and like
yeah,
we are binded with United Nations,
yes.
and
So there is an international law that is governing the countries. So there is
f-
proper law and order. So that is why international law is being required. So
for
for suppose
peace
if any trade dispute is there, then also there see in the later next chapter late. So I will be doing this arbitration proceedings and all. So there you
and
will be
there
learning
is
more
European
about
Union also, the 28,
yeah,
27 countries of Europe,
yeah.
they
So
are binded with
yes, there you will,
international system.
yes, yes, very good. There you will be learning more about it. So why this international law is there? The reason you know. Okay. So international law deals with matters such as the formation and recognition of the states, acquisition of the territory, war, the law of the sea and of space, the treaties, several treaties are there, agreements are there, treatment of aliens, human rights, international crimes, and international judicial settlement of dispute. That will be done in very detail. So there are various sources of international laws. The conventions are there, several, the treaties are there, the international customs are there, the general principles of law that is being recognized by the civilized nations. For example, European Union is a collection of nations, as you were mentioning right now, which have agreed between them some common laws by signing conventions and treaties. So what is it? This is a public international law. You may also come across the term private international law. This is the part of a nation's own law that will be done in the next chapter that establishes rules for dealing with cases involving a foreign element. So, what could be the criminal law?
The way country handle cases for dispute of crime.
Crime, which is related to crime, okay? In simple terms, if you're going to say something which is being related to crime. Okay. So criminal law, it is a branch of law that defines the conduct which is being considered as something which is unethical, harmful, or moreover threatening to the society, and order of safety, and prescribes the punishment of such conduct. Crime is what? It is something which is very unethical, illegal. If you're doing such kind of things, that is a crime. It is primarily concerned with offenses which is against the state, public order, or even morality, even if the immediate victim is an individual. So, what could be the purpose of criminal law? The core objective of criminal law is to deter individuals, abstain them and the public from engaging any unlawful conduct means which is against the law. Which is against the law, which is actually any immoral conduct. Punish offenders who violate the criminal statutes. Rehabilitate those who are found guilty where appropriate. Protect society by incapacitating dangerous individuals and provide justice for victims and uphold the rule of law. Now comes the nature and characteristics. First is public in nature, that is, criminal proceedings are typically brought by the state and not private individuals. Standard of proof, the prosecution must prove the defendant's guilt, that is beyond a reasonable doubt, which is the highest standard of proof in law. Presumption of innocence, like every accused person who is being accused of a crime that being committed, a person who has been accused for committing a crime is presumed innocent. You cannot say a person is a convict until and unless it has been proven that they are guilty. Example of criminal offenses is, why is this line being mentioned that the accused person should be presumed innocent until and unless they are proved to be guilty? Why is it so?
Because on the basis of our judgment and our personal feeling of gut, we cannot say that that person is guilty. Basis on facts, we and the events, we and it get proved, then we can say that the person is guilty or a person is convict.
See, what happens is when something is being related to crime, so there is somewhere a person is getting a punishment which is very strict or tougher depending upon the crime. For suppose a person who is not even guilty and is being accused of a murder, for example, I'm just saying hypothetical situation. So the kind of sentence that person will be getting will be extreme, even though they have not committed. So you can't say that a person has being committed a crime until and unless that is being properly proven. Secondly, if a person is staying in the society for so that person will get a bad mark. That person has to stay. So until and unless it is proven you can't commit someone, it is which is immorally correct. Right? Clear with it?
Yes, ma'am.
Okay. Then comes the violent crimes, that is murder, assault, and robbery. Property crime is basically related to the theft, vandalism. Then white collar crimes, fraud, embezzlement, or insider trading. Are you aware of insider trading?
Yes, ma'am. The person who sell their organization
Leak
information to other
inside
party for some
information
money.
of the company in order to manipulate the prices of the share, right? Cyber crimes is hacking, identity theft, online harassment. Regulatory offenses, that is violation of environmental or safety laws. So this is all about the criminal law. Then comes the civil law. It is again a branch of law that is being governing the private rights and the relationship between the individual, organization, or both. That is more of a private law that is governing the individuals. So it is primarily concerned with the resolution of a non-criminal dispute. Any sort of dispute that happens between the individual which is not criminal in nature. So what kind of dispute could be there that is not criminal in nature?
Dispute could be property dispute,
Property dispute.
family
Very good.
dispute.
family dispute. So these are kind of dispute that are not related to the crime. So what will apply? Civil law will apply over here. Unlike criminal law, where the focus is on punishing the offenders, civil law seeks to provide remedies such as compensation or specific performance to individuals who have suffered harm or loss due to the action or omission of others. What they're trying to say over here is that under criminal law, a judgment is being passed depending upon the nature of the crime, like what they have to suffer. But here, what they're trying to say is that instead of punishing the offenders, what they're trying to do, they're going to try to resolve the conflict by how? See, for either they could ask any of the party to provide the compensation to other party, or they could ask to do certain action, that is the specific performance, depending upon the scenario to scenario, whatever the nature of you can say the cases. So depending upon that, the remedies are being sorted. So the key objective of civil law is that they protect the individual rights and interests, provide legal remedies when those rights are being violated, resolve dispute fairly through courts or tribunals, ensure accountability for the wrongful acts not being classified as crimes. So the characteristics of civil law is they are mostly private in nature. So the case is usually brought up by an individual or entity that is being called the plaintiff against another individual, that is the entity called defendant. A person who is filing the suit, who feels that they are being done wrong, is known as the claimant or the plaintiff. Against whom that is being filed is known as the defendant. Standard of proof, now the cases.
Ma'am, who is claimant and defendant? Please explain again.
For suppose a property dispute is being going on between A and F. A says that, okay, F has acquired the property of A, which belongs actually to A. Now, A has gone to the court for the particular case. Okay, I want my property back, which is being illegally acquired by F. Now, A is filing the petition to the court. So, A will be the claimant or plaintiff, and who will be the defendant?
F.
F. Okay. Now clear?
Yes, ma'am.
Now comes the standard of proof. Cases are being decided on a balance of probabilities, meaning the judge determines which party's version of fact is more likely to be true. Now it depends upon the judge. Whatever the you can say the evidences are being produced, the documents are being presented, whatever judge feels is correct or likely to be true, depending upon that, they provide the judgment. Outcome usually results in a monetary award or an injunction or an order for specific performance rather than imprisonment. Imprisonment is most likely to be applied in case of criminal law. Example of civil law cases is contract law, that is dispute over agreements. For example, a company
Ma'am,
failing.
here injunction term means injunction.
See, it depends upon the scenario. Like if, for example, if a court says that this property, for example, belongs to A or belong to F, that will be the scenario. That is, there will be the injunction. Okay. In simple terms, if I'm going to explain it to you. Or
Simply they decide that this
Yeah.
property is going to
Yeah.
for F.
Yeah.
And there is no compensation paid by A or F, whatever.
F. It depends
Okay.
upon, it depends upon scenario to scenario, case to case.
Basically, they finally made a judgment.
Yeah.
Okay.
So, for example, contract law, that is disputes over agreement, company failing to deliver goods as being promised. Tort law, that is claim for wrongful acts that are being caused, that are actually causing harm, that is personal injury, defamation, negligence, defamation,
Ma'am.
causing disrepute to someone. for example, you are defaming, like you are somewhere, a person is spreading a wrongful word about a company or a
Offensive
particular
word.
person in order to make them defame them. Okay.
Okay.
Then comes the family law, that is matters like divorce, child custody, and maintenance. So if there is any sort of dispute within the family or any divorce proceedings are there, where it will go? Under which
Civil
law?
law.
Civil law.
Civil law.
Employment law, like issues against the wrongful dismissal, which is being filed by the employee, or workplace discrimination is there. So again, there will be a civil law. So here comes the difference between the civil law and the criminal law. Parties involved, that is individual versus the individual or entity. Here is the criminal law. It is mostly towards the state versus the individual. Objective is compensation or remedy. Here, the punishment or the deterrence. Burden of proof is balance of probabilities. That is, either could be there, either A could be correct or F could be correct. Whatever it is, solution is being sought, remedy is being provided. Here, it should be a beyond a reasonable doubt, means that there should be proper conclusive evidence should be there. It should not be something which is not being proved. So burden of proof is very high. Outcome is damages or injunctions, or here it will be imprisonment, fines, or community service. So this is, I have taken up for your understanding. Now when I'll be explaining it to you from the book, it will become
Ma'am,
more clear.
community service means in criminal cases refers to community service. What?
If community service, what do you understand by this term community service?
We have to serve our society.
Society. Okay. So how it is being related to crime?
Like, I don't know. I didn't know.
Related. You can do it. Try.
We have to do some kind of
Try. You
servant
will
type,
be able to do.
servant type something.
Servant time means?
Like, let's say someone has done crime.
Okay.
In community service here refers to like they have to serve lifetime, clean the roads. I
Okay.
don't know actually exactly.
You do. Acha. You are not clear with the term community service. I think so.
Yes, ma'am.
So what if I'm with, okay, I will break it down for you. What is a community?
Group of people.
Okay. Group of people, then service, what does it mean?
Service is something which is not in physical form. We are providing services.
So, okay.
Not
If
in good.
community and service are being combined together, so what will it be?
I am providing services to the group of people.
Service to group of people, fine, very good. So, how will it be relating to crime? Think of a scenario.
So crime is a very hard,
A crime could be anything,
but
any
the
sort
standard
of,
of
even it could be theft, even it could be theft, then also it's a crime, right?
yes, ma'am.
So under this,
But the theft cannot be under a criminal law. It can goes to civil
it is not
laws.
under criminal law. I have done it
We
right
just
now.
studied
Yeah,
that theft.
I have done it right now. Were you not attentive?
I think that theft
It
is
was
under
not
a
there.
civil law.
It was under property crime.
Okay. Oh,
Yes.
property crime. Oh, yeah, property
Yeah, it
crime.
was there. Vandalism, theft.
Yes, ma'am.
Yes. So how it is being related? The outcome, how it is being related to community service? See, either there were imprisonment or fines were being imposed or community service was there. This,
One example of community service.
okay, if any social act is being done, like NGOs, for example, what they do, they are providing certain kind of services which is related to the social welfare for the general benefit of the public, right?
Yes, ma'am.
Various several NGOs are there that is being working towards women empowerment,
Yes, ma'am.
right? So that is a sort of community service. You are serving the community somewhere for their benefit, right?
Yes, ma'am.
So as a punishment, a person who has committed the crime, so what the court may order, you have to do this community service in order to make him morally uplift him or her, depending upon the accused, right? Morally uplift that person and to make that individual a better human being so that they avoid doing this further. See, community service will, this kind of punishment will apply in which scenario? What could you think? In severe crimes or minor crimes?
In minor crimes.
Minor one? So,
Yes, ma'am.
for example, a human being is there. Human beings are meant to, uh, like, they're not perfect. Somewhere anyone can go wrong, right? At any point of time. But this doesn't define that human being. Anyone can do any sort of wrong act. As an individual, we all do certain mistakes, right? But that mistake don't define us. At a certain point of time, a person has committed something. It could be for any of the reason, under influence. Some people commit crime just because of the need, because they need money at that moment of time. So they resort to wrongdoings, which is absolutely incorrect. But due to certain reasons, which is their personal reason, at times this type of scenario at occurs also, that people are get into such things, which actually don't define them. Okay, so what these kind of laws that is related to the community service, it is being brought up in order to make society a better place. So a person who has committed such kind of theft, though that person was not actually wanted to commit, might have committed due to certain XYZ reason, but that doesn't mean that person has to live with that mark. Or if a person has committed certain kind of mistake, any mistake, so they could be uplifted to do a better deed, right? And
Yes, ma'am. Now I got it.
community service is a very good deed. So that is why they are made to do such kind of acts, to make them a better human being. Fine?
Yes, ma'am.
So in law, this you have to keep in mind that you have to think from a broader picture. Okay? Once you will start enjoying the subject, you will love it. Here, criminal law, a crime is being conduct prohibited by the law, whatever crime is being conducted. The state prosecutes the case because it is the community as a whole which suffers as a result of the law being broken. In a criminal trial, the burden of proof to convict the accused rests with the prosecution. The prosecution must meet the standard of proof, which means having its case beyond reasonable doubt. That is, one has to prove it. There should not be any element of doubt. Punishment for committing crime is usually by means of fines or imprisonment. However, in some circumstances, the court may make a compensation order by which the criminal must pay some compensation to the victim or their family. They may ask the person to pay in terms of the monetary terms. Some legal system based on Sharia or Islamic law contains the concept of the qisas or retribution that I will explain you in the later chapter. In certain cases, these give a legal right to inflict on the wrongdoer the same hurt that they have perpetrated on the victim or to accept dilyat compensation instead. So this provides some compensation to the victim of the criminal activity who is not necessarily considered in the Western law. In the West, the focus of the law is mainly to punish the wrongdoers. Victims might have to undertake a civil law action in order to receive the significant compensation. So here basically the understanding of the criminal law is being there, which I have explained you through the notes. Then comes the civil law. They exist to regulate a dispute about the rights and regulations, obligations of the person when dealing with each other. It is a form of a private law. In a civil case, the claimant sues the defendant. It would therefore be referred to as, for example, Smith versus Mega Corp PLC. That is the case. One of the most important areas of civil liability for business and accountants in particular is the law of trade and conduct. So in civil proceedings, the standard of proof means that the claimant must prove that the case has been based on the balance of probability. So now comes the common law system. So now I will be giving you a 10 minutes break. After that, I will be connecting with you, okay? Okay. Are you back now? Yeah? Okay. So now comes the common law. So common law is basically a legal system that is a body of law that is primarily developed through the judicial decisions and court precedents. Judicial decisions means the decisions that are being passed by the court, whatever the cases were, any decisions that are being decided upon by the judges of the court, that will be the system that common law abides by. And then comes the court precedents. So precedents are something, these are also the basically the legal decisions that are being taken by the judges in the past, which helps in deciding the cases like which are more similar. So based upon the past decisions of the court, the future cases are being decided, which are actually very similar. It is not that they're unlikely in nature. So these are also being considered rather than solely being dependent upon the written statutes or the legislation. It is originated in England and now forms the basis of legal system in many countries, including UK, US, Canada, India, and Australia, and among others. Key features of common law is the foundation of common law is that judges interpret and apply the law that is based on the previous judicial rulings known as the precedents. Now, the doctrine of precedent says that courts are bound to follow the legal principles that are being established by the higher courts in earlier decisions when deciding the similar future cases. This ensures more of consistency since the decisions that are being taken by the judges are more consistent. Predictability is there now. The people know what kind of outcome will be there, what kind of rulings will be made by the judges, and fairness in the legal system. Unwritten sources, like although many laws are now codified, common law still heavily relies on case laws like the recorded judgment that are being passed from the previous rulings rather than the formal written codes. Evolutionary nature, common law is very dynamic depending upon the case to case, since it is not solely depending upon the legislation, the statutes, and is being evolved over time. How evolving? Because now the new cases will come, the new rulings will be passed, and that could be used for further judgments. So this way it is evolving as courts interpret new situations and societal norms changes. So structure of common law system says that statutory law, that is the legislation, laws that are being enacted by the parliament or the legislature, case laws like the judicial decisions, interpretations and application of law by judges, When no statute applies, judges relies on precedents and legal reasoning to decide the case. So example over here is, suppose there is no written law stating whether company is being liable for environmental damage that is being caused by the subcontractors. So there is no specific law in the country. A judge in deciding such a case may look at past rulings that are being made by the court on corporate responsibility, and then they come to a conclusion, the decision. This judgment then become precedent for the future similar cases. Now based on these decision that is being passed, now future similar cases could be decided upon. Clear this part? Okay. Now comes the difference between the common law and the civil law. So common law was originated in England and civil law is a Roman law, that is continental Europe. Primary source is the judicial decisions, that is the precedents. Now you know the term precedents? Yes? What is precedent? Is there some problem with the mic, Ritika? You can write it down, there is no issue, but I want to know what you're understanding.
Yes, ma'am. Precedent, we can say that the law which is like the decision which is made by past, and that decision is now becoming a precedent. Like Supreme Court's passed some decisions, and that decision is becoming a precedent for further
Okay.
further
Any
reference.
decision that is being made, any rulings that is being made by the court, right? That is being used to decide the future similar cases.
Cases.
That will be the precedents. So now if a judicial precedents come, now you know what is the term means?
Yes, ma'am.
Okay. And civil law, it is based on the codified statutes. That is also the written law and the legal codes. Then comes the role of judges. What is the judges doing actually? Here they are interpreting the law and creating the binding precedent. That is, whatever the cases that are being decided upon becomes binding on the individuals. They abide by that, they follow that. Apply the law as being written in courts. Legal flexibility, it evolves case by case. And this is more rigid and systematic. Countries that are using common law are the UK, US, India, Australia. Here, the France, Germany, Japan. Here, mostly civil law is being used. Now comes
But
the
ma'am, India follows civil law also, no?
yeah, they follow. Yeah, just the example is being taken. Okay, just for
Okay.
your reference. It's not that it's a concrete example. It cannot vary. Fine. It's just for your understanding. It's being given. Now comes the equity. So if equity term is there, so what do you understand by this term, equity?
That balance sheet equity.
No, no, no. Normally equity. Not financial statement terms you have to specify. Just if you're saying equity, from which term it is deriving, which main word is there? Equity could have derived from.
I don't know. I just know
Equal?
the term equity from the
Equal?
financials purpose.
Okay, no, no. Okay, I'll make you understand. From the equal, somewhere equity has come.
Yeah.
It's balance, equal means
Yes.
equity. So if I'm going to say equity in terms of law, so what could you think of?
Equal in eyes of law.
Equity is something which is being related to fairness. Okay? You are more fair in your nature. Equity means you are not biased, you are unbiased. There is something which is involving sort of moral impact. You are somewhere taking decisions that are more fair, that are more morally right. apart from being legally correct, it should be morally right also. Okay? Morally, why? Because human beings are being involved. As you've seen in the previous example, which we were asking, how the community service is being related to the criminal law, right? Community service could be anything. Either it could be like cleaning of the streets also, right? So here, equity involves something that is being related to moral aspect, apart from being legally correct. So equity is a branch of law that is being developed to supplement and correct the rigidities of common law by ensuring more of fairness. There is more fair attitude, more of justice and moral conscience in legal outcomes. It is not that something is being applied to one case scenario. It is not important that same thing is being applied to the another. It might be the grievance could be different. Somewhere it might be high, somewhere it might be low of the scenario. So there is more of fairness, there is more of justice or moral consciousness involved. It is originated in England as a system of justice that is being administered by the Court of Chancery, where litigants who could not find adequate remedy under common law could appeal directly to the King or the Lord Chancellor. Now, what is the purpose of equity? It is to provide just outcomes where strict application of legal rules would cause injustice, to offer more flexible remedies when common law remedies like the damages are being insufficient. Now comes the key principles of equity. Equity respects legal rules but will intervene where strict application of those rules will lead to more of unfairness. He who comes to equity must come with clean hands. Now, this is the prerequisite that is being required. A person who is seeking equitable relief must act fairly and should be acting very honestly. You can't manipulate or defraud other in this term also. A person should be very fair and honest in the approach where a person is seeking more of equity. If you are seeking fairness, then you should be a fair person, right? Simple terms.
Yes.
Equity acts in personam, like equity binds the conscience of the individual, focusing more on moral fairness. Delay defeats equity, like doctrine of lashes, like a person who waits too long to assert a right may deny relief. Equity looks to intent rather than the form. What is the intention behind? Okay, that is, it is prioritizing the substance. What is the actual intention? And overlooking the technicalities, the legal aspect. So here the intention matters. Here even though the court case is being decided upon the legal aspect. Okay, this happens, this will happen according to the legal terms. But somewhere morally it is wrong. Okay, the scenario might come, any case could come. So that way the equity shall apply over there. Equitable remedy, like first is injunction, that is court order to stop a person from doing something. A court may order, okay, you can't do this act. Okay, so here the injunction will be applied. That is where a person might be violating the contract, might not be following the contract. So the court may order to stop that. So there is injunction. Specific performance, order to perform a contractual obligations, they may ask you to do a certain act. Injunction, they may asking not to do or stopping from doing something. In specific performance, they may ask to do or they may ask not to do. Anything could be happen. Rescission, like cancellation of a contract. Rescission means cancellation due to misrepresentation or fraud. Rectification, it means you're amending something, rectifying something, that is correction of a written document to reflect the true intention of the parties. Constructive trust means imposed by court to provide more of unjust enrichment. There is no unjust attitude or unjust solution should be provided. So that is being imposed by the court in order to provide more of fairness. Here, example could be there. Imagine two parties, they enter into a contract for the sale of a rare painting. One party refuses to deliver the painting. under common law, monetary damages might be rewarded. But since the painting is unique, equity allows the court to order specific performance, that is requiring the actual delivery of the painting. Fine. Here, what
Yes,
is it?
ma'am.
A contract is being there. A seller is saying, okay, earlier they have decided that seller will be selling the painting. Later on, he said, no, I will not be doing the same. So now the court may decide, okay, you have to give the painting, you have to deliver it. So now here fairness is being applied. Fine.
Yes, ma'am.
Now I'll go to the book. So, although the common law was developed in England, it has been exported globally as a result of the British Empire and Commonwealth. It is the basis of the legal system of the USA, and we shall use England and US as the exemplars of the system. Key principles of common law are: principle of law do not become inoperative through the lapse of time. That is, whatever law that is being decided upon or forced upon, it will not become inoperative, will not be cancelled. For example, you can say it through the passage of time, even though time has been expired. Law does not become irrelevant or invalid just because it is being old. Once it is being decided upon, it shall follow even in future, very future. This applies to all sources of the law. Net laws do not alter the do not alter the existing law. So whatever law that is being developed by the legislature are presumed not to be altered, merely to add to or the existing law, whatever it is being added or new law comes up, but it shall not alter the existing law unless they specifically state otherwise. It is the, you can say, that is being provided. If something is there that is very exceptional nature, so exceptions is being given over here. Judicial precedent: a judge is bound to apply a decision from the earlier case to the facts of the case before them, provided among other conditions that there is no material difference between the case. One judicial precedent shall not apply to the other if it is very unlikely in nature. One has to be similar in order to apply those decisions. Now, the sources of law in England are common law, equity that is based on common law, statute, and the custom. Now, what is statute? Have you come across this term?
No, ma'am.
Again, statute is also an official law that is being made by the government, okay? It is an official written law. The US also has a significant additional source of law, that is American Constitution. American Constitution is the ultimate source of law in the US. Any statute that is being passed by the American Senate or by the federal government or in individual states may be challenged by a citizen on the ground that it is being unconstitutional. So the UK Constitution sets out the basic rights of the US citizens and the system of government for them. Equity that is being developed 2 or 300 years after the common law. As the system of law that is being applied by the Lord Chancellor in situations where justice did not appear to be under common law principles. Why was equity being introduced? See, once common law was being introduced after 2 or 300 years that the equity was being proposed or it has been come up. What could be the reason for it?
As you said that it is a supplement of a common law. So common law maybe in some area it gets rigid. So equity plays a role there.
Correct. So in order to be more morally correct, more fairness is there, more justice is being provided. So here equity was being proposed. So the common law, the body of legal rules, common to the whole.
Ma'am, ma'am, can you explain the American Constitution?
American Constitution is the source of law in the US. That you have to remember, okay? That is sufficient for you. In England, what are the source of law?
Common law.
Right, then
Common law.
look at the
They
book and
are
answer me. Book, it's being displayed on the screen.
equity, statutes and customs.
Custom. And for American, US,
American
Constitution, these are only the source of law. Fine?
Okay.
So now comes the changes that are being brought in by the equity. The interaction of equity and common law produced three major changes. First is the new rights. Equity recognized and protected rights for which the common law gave no safeguards. Better procedure, equity may be more effective than common law in resolving a disputed matter. Better remedies, like standard common law remedy for the successful claimant, was the award of damages for their loss. The chancellor developed remedies not available in the other courts. So there is more equitable, there is more fair remedies. Remedies available to a claimant under equity includes: first is the specific performance, an order requiring the defendant to do what they had agreed to do. Who is the defendant?
Defendant is those person who like claimant I have
Against
something
against
against the
so
claimant.
basically the person against whom the claimant has filed a lawsuit, right?
Yes, ma'am.
Okay. So here what they're saying, specific performance, an order requiring the defendant to do what they have agreed to do. Second is injunction, an order requiring the defendant to abstain from wrongdoing, to protect or prevent, basically prevent them from wrongdoing. Rectification is an order requiring a document to be amended to reflect the party's true intention. Rescission, an order requiring the restoration of a pre-contract status quo, like whatever the decision was being made before the contract was being entered upon. So you have to come up to the terms. So here the question will be like the remedies that are being available to a claimant. Now the four options will be given to you. Either like three options will be given or two options will be given depending upon the question requirement. The examiner may ask you correct the two, or all of the above will be there, or any one will be given. You have to select the correct one. So you should be knowing that what kind of remedies are there. First is,
Specific performance,
second is,
injunction,
third,
rectification,
fourth.
rescission.
Simply you have to learn this, okay? In
Uh,
objective
this
questions, you
type
will be
of
getting.
question can come like if they give a
Yes, yes.
case study
Yeah. See, every
and
chapter I will be
they
completing after.
instruct to
Yeah,
yeah.
sorry.
Uh, yeah, ma'am, in exam, this type of question can come like if they give us case study and they give a four options and ask which of these is best suitable for this case.
Yeah, see, they may, here the questions are very direct, okay, in law. They will not make you think like this could be applicable, though. Questions are very direct. They will simply ask you what are the remedies that are being available to a claimant. Four options will be there. Either the specific performance injunction will be given, A part or D part will be there, both of them, neither of them, and two, B and C, specific performance and injunction will be there, okay? Either three of them will be given, or either fourth option will be all of them, or either one could be given. You have to select the one part. So very direct question will be there, okay? What you have to do on your part is you have to learn it. They will not manipulate you. In the scenario based also, questions are very direct. I will be doing questions simultaneously with the chapter. I will be completing one chapter and I will be doing the question answer from that. From the time you will be doing questions, you will gain confidence eventually, okay?
Yes,
And you will be getting an understanding how questions will come.
okay.
Fine?
Yes, ma'am.
So here comes the case law. So the common law and equity form what is known as the case law. Once the case is being decided upon, a decision comes based on the common law and equity. What it becomes? It becomes a case law. Case law is a significant difference between the common law system and the civil law system. Case law incorporates decisions that are being made by the judges under both historical legal system, and the expressions common law is often used to describe all cases law, whatever its historic origin is. A court's decision is being expected to be consistent with the previous decisions and to provide an opinion which can be used to direct future relationship. Now comes the
So
statute.
if there is a case which decision is incorporated with equity,
Yeah,
then it will become a case law.
yes. Once
Okay.
the decision is being taken up by the court, by the judges of the court, that becomes the case law. Okay?
In common law, like based on past precedents or new precedents.
Yes. Based on the past precedent, see, common law involves both legal precedents as well as judicial precedents. So whatever is being decided upon, again, the equity is also being applied, the fairness. Now the final decision comes, that becomes your case law.
Okay. When equity incorporated, it becomes a case law.
Yes.
And if equity is not incorporated, the decision is made on the basis of
Again,
past precedent.
yeah, it could be it could be it could be referred as a more of a judicial precedent.
Okay.
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 So statute in the UK, the legislature parliament is said to exercise more of parliamentary sovereignty. This means it can make and repeal laws, cancel laws, as well as overrule or modify the case law, which is being created by the judiciary. Statutes are made by parliament or in exercise of lawmaking powers, delegated by the parliament, known then as delegated legislation, or in the civil law system known as the administrative legislation. Now comes the role of judges. Judges play two roles in building up case laws in common law system. That is by setting and applying the judicial precedent. Whatever case scenario is there, depending upon the previous similar cases, you are applying the similar decisions. That is the judicial precedent. And then they are applying then they are interpreting the statutes. Whatever the laws are there, interpreting that. And they also perform the important function of the judicial review. Whatever the review is to be done of the case, they also do that. So the English legal system comprises a hierarchy of courts. In terms of the status of the court for precedents, you should be aware that lower courts do not create the binding precedents. Why?
Because lower court follows the precedent of higher court, which made a precedent.
Any case is being filed, any lawsuit is being filed in the lower court, does the claimant or defendant, depending upon the scenario, they go to the higher court when they are not satisfied with the decisions that are being made by the lower court?
Yes, ma'am, they can do.
So the court, any case that is being decided, for example, in India by the Supreme Court, that will be considered as a binding precedence.
Yes, ma'am.
That is what they're trying to say. They are bound by the decisions of the higher courts, each of which is bound by the court higher to itself. Judicial precedents when deciding a case, a judge's decision is expected to be consistent with the previous decisions that are being taken. It should provide an opinion which the parties and others can use to direct their future relationship as it creates a law. This is the basis of system of judicial precedent that I have already explained it to you. It has three elements. That is, first is the reports. That is, again, it's just give me a minute. Are you having this book with you?
Yes, ma'am, I have a Facebook.
So now the judicial precedence is based on three elements. First is the reports, that is, there are comprehensive law reports of earlier decisions. Whatever the decisions are being taken, that is being incorporated in the form of a report. Then rules, that is, there must be rules for extracting a legal principle from a previous set of facts and applying it to the current facts. Classifications are there. Precedents must be classified into those that are being binding and which are merely persuasive. So, four rules must be considered when examining a precedence before it can be applied to a case. First is a decision must be based on the proposition of law before it can be considered as a precedent. It may not be a decision on a question of fact. It must form part of the ratio descendancy of the case. The material facts of each case must be same, and preceding post must have had a superior or in some case equal status to the later court such that the decisions are being binding on the later court. I will like you to please go through these points once, then I will explain it to you. Okay? Just read it by yourself. So while reading, are you getting something? Understanding what they're trying to say? Or are you facing difficulty?
Ma'am, I am still reading.
Yeah, sorry.
Ma'am, I am still reading. I
Reading.
haven't
Okay, fine.
completed it.
Let me know once we're done.
Yes, ma'am, done.
Okay. So were you facing some sort of difficulty while understanding?
Yes, ma'am, some points are not clear.
Not clear, right? Okay. So first point says that I'll break it down for you. A decision must be based on the proposition of law. What is the proposition of law? Means that it should be a clear law, a clear definitive rule should be there. Okay? Before it can be considered as a precedent, whatever decisions the judges are taking should be based on proper rules, right? It may not be a decision on the question of fact, right? Which says that it should not be simply decisions that is being taken on the evidences that are being produced or the question, like whatever the facts are there, or like several instances are there which provides that, okay, these are the question of facts. Decision should not be based on that. It should purely be based on the rule. Okay. What is the definite actual law that provides? Second, it must form part of the ratio decidendi of the case. Ratio decidendi means you can the reason why this decision was being taken. If a judge is coming to a conclusion or making any decision or passing any decision, so what could be the reason for it? So it should be a former part of it. The material facts of each case must be the same. The preceding court must have had a superior and in some cases equal status to the later court, such that its decisions are being binding. Which they are trying to say is that if a court is following some decisions that are being taken by the other court, that is a judicial precedent. So somewhere they should be nearby. The preceding court should be somewhere, you can say, should have a superior or somewhere equal status. It should not be the somewhere lower court has decided the case and that they are following. It should not be like that. Somewhere similar or superior. Fine.
Yes, ma'am.
Are you clear with the 4 points?
Ma'am, D point is not clear, very clear.
Tell me.
Like what it is saying, superior or
Superior. Okay. Whatever. See, I'll give you reference to the India. Okay. Various regional courts are there, district courts are there, fine, and high court is there. If a
Yes,
court
ma'am.
needs, or and supreme court is there, 3 levels are there. If a
Yes,
high
ma'am.
court wants to decide any case, will it be referring the case decided by the supreme court or the lower district courts,
Obviously Supreme Court.
or will it be also referring the high court of a different state?
No, different states have a different culture also.
Sorry, your voice, Ritika, is not clear.
They can refer different high courts.
But they basically they will be referring somewhere who is at their level, the high court level or the supreme court. Will they
Yes,
be
ma'am.
deciding cases based upon the judgment that are being passed by the district court, the lower courts?
No.
No, na? That is what they're trying to say. Clear?
Yes, ma'am.
So ratio decidendi is the principle that a judge followed when coming to their decision. What was the reason for coming at a decision? For their decision. Avoiding judicial precedents. A precedent in a previous case can be avoided by a judge in the following ways. First is distinguishing on the facts. That is, a precedent is only binding if the material facts of the later case are the same as the previous one. This is a matter of judicial precedent. Overruling precedents may be overruled by the High Court. As we have discussed, it may be overruled by the higher court. Other than the court that has set them, this tends to be a rare case, particularly if the precedent has existed for a very long time. Per incurium, wherein earlier decisions that was being made with a reckless attitude, that is was without any care, without taking into consideration any legal rules. Okay, it was being taken without any care. So in that case, the precedent that is being decided in a previous case could be avoided by a judge. Fine?
Yes, ma'am.
Okay. Now I will be concluding the today's class. I will be starting this chapter, the rest of the chapter in the next class. So any questions so far you have, Ritika?
No, ma'am, so far no questions.
Fine? Okay. Then I will see you in the next class. That will be in the next week.
Okay, thank you, ma'am. Have a
Thank
good day.
you. Thank you.